The House Select Committee investigating the January 6th Capitol attack completed its last scheduled public hearing until September on Thursday. But I want to take you back to their fourth hearing, back on June 21st. That day, the committee presented a deep look inside a scheme of Donald Trump and his loyalists to refuse the certification of Joe Biden by rejecting the slates of electors from 7 key states. Now, the extensive testimony revealed how Trump, Rudy Giuliani, and John Eastman, among others, tried to gather up alternate and phony slates of electors in a plan that would end up having Mike Pence declaring Trump the winner of the 2020 election. It was quite the plot, and it was potentially criminal. But here's the thing. According to legal experts, the ambiguous and outdated language in the Electoral Count Act of 1877 opened the door for this plot to even be considered in the first place. And now, Congress is trying to make sure those issues are actually addressed. On Wednesday, a bipartisan group of 16 senators introduced legislative proposals, the Electoral Count Reform and Presidential Transition Improvement Act and Enhanced Election Security and Protection Act. Together, they would reform and modernize the Electoral Count Act in several ways. For one, right now, the law only requires one member of the House and one member of the Senate to challenge any state's set of electors. The new language would raise that requirement. About 20% of the members of each chamber would now be needed to contest a state's popularly voted electors. And can the vice president really just decide to overturn election results? Well, back in January, Trump said in a statement that Mike Pence could have. He issued a statement attacking Congress for trying to put together this reform bill, saying in part, quote, "Unfortunately, he, as in Mike Pence, didn't exercise that power. He could have overturned the election." The vice president can't do that. Let's be clear about that. No vice president ever could have done that. But Congress's proposal would make this explicit, spelling out that the constitutional role of the vice president in presiding over the count is solely ministerial and that he or she does not have any power to solely determine, accept, reject, or otherwise adjudicate disputes over electors. The legislative proposals would also get rid of old language with undefined terms like failed election and lay out how Congress can more definitively identify legitimate slates of electors from each state. Now, at the hearing on Thursday, committee member and Republican Congressman Adam Kinzinger alluded to the need for these kinds of reforms.
When we present our full findings, we will recommend changes to laws and policies to guard against another January 6th. The reason that's imperative is that the forces Donald Trump ignited that day have not gone away.
So what should we make of these proposed reforms so far? Are they big steps or not enough? Joining me now is perhaps the country's leading election law expert, Ned Foley. He's a professor at Ohio State University's Moritz College of Law. He's also the author of the 2020 book, Presidential Elections and Majority Rule: The Rise, Demise, and Potential Restoration of the Jeffersonian Electoral College. Ned, it's great to have you with us. Thank you so much for making time for us. What are your thoughts on these new proposals to reform the Electoral Count Act? Did anything stand out to you as particularly important?
Yes, so thank you. I do think this is an important bill. It would be a vast improvement over the current law. As you said, the law from 1887 is outdated, convoluted, in language that's hard to understand, and this would be so much better than that. It would avoid the problem that you were talking about earlier, this desire on the part of a candidate to subvert the process by replacing the true vote of the people with some alternative fake vote or bogus slate of electors or what have you. And this law, this bill, if adopted, would address those concerns.
Last month, in an interview, you said with The New Yorker, you said, quote, "As long as we retain the constitutional provision for the Electoral College, we won't be completely out of the woods. As long as we have an Electoral College under our Constitution, we have a lot of vulnerabilities." I would love to get your thoughts on that. Walk me through what you mean by that. Is it not enough to reform the 1877 Act and to protect us from what almost happened on January the 6th? What should be in this new idea or proposal of yours?
Right. Well, as you said, Trump had this idea to have the vice president take unilateral authority, regardless of what the people wanted with their votes. That idea really comes from the 12th Amendment of the Constitution, unfortunately, which does have some ambiguities in it. But as you said, what this new bill would do would be Congress saying, for purposes of Congress's role in receiving and counting the electoral votes, they're not going to let that ambiguity make a mess of things. They're going to insist that the vice president doesn't have that authority. So yes, we would be safer if we had a clear constitution, but the best that we can do absent a new constitution or constitutional amendment on this issue is to have a better statute, and that's what Congress is trying to do here.
Do you think we should abolish the Electoral College if we wanted to have the most direct and secure voting mechanism or voting process that cannot be tampered by any of these procedures, if you will?
Yes, in the book that you mentioned, I say it would be best for our country to replace the Electoral College with what's called a national popular vote, where all the citizens count equally in one nationwide vote. But again, that would require a constitutional amendment. So, getting ready for the next presidential election, we have to work with the system that we have. And the way to do that is with the law that the bipartisan senators introduced. We can do something different down the road, like get rid of the Electoral College. But in the meantime, we have to fix the flaws that we have in front of us.
One of the things that caught my attention as well is what you said about the January 6th committee's investigation and public hearings needing to investigate members of Congress who also violated the law. I feel like that does not get enough attention. You say in part they need to focus on Trump's attempts to pressure Pence, but the real danger here is self-abuse by Congress. If there's ever going to be a successful coup, it will be committed by Congress itself. And I don't think that's gotten sufficient attention. Those are your words, and I completely agree with them. Tell me more about that and why we haven't paid enough attention to the fact that a coup would actually require somebody from Congress to be complicit in it.
Right. Well, you mentioned Senator Hawley and his role on January 6th, and I think that unfortunately was critical. If he hadn't objected, he was the first senator who said he was going to join with the members of the House of Representatives who were trying to organize this effort to undo the Electoral College victory, which had occurred back in December. If you don't have a senator, that process can't go anywhere. And so he gave that momentum leading up to the violence on January 6th a lot of energy, if you will, by saying he would sign on. It might have dissipated if he had said, this isn't going to go anywhere because as a senator, I'm not going to let it happen. Now, after he got on board, there was some other senators who did as well. But that's just emphasizes the point that we're talking about. It's members of Congress who have it in their hands to abide by the true results, or instead members of Congress for partisan reasons might try to upend the results and replace the results. And that's what's so dangerous.
I got to ask you really quickly about this big Supreme Court case coming out of North Carolina. Do you worry that by reforming the Electoral Count Act, this could provide some legal cover for folks like John Eastman from potential criminal prosecution, that they could look at this and say, by pointing to this reform effort and say, look, it's evidence that their actions were somehow technically within the law? Because we now know that this case is working its way up from North Carolina, challenging whether state courts have a say in the electoral process that comes out of state legislators.
Well, here I think there is some good news. It is true that that Supreme Court case is pending, but whatever happens in that court case, Congress has within its power to fix this old law from 1887. And if Congress does the right fix, that Supreme Court case will be irrelevant to the task of counting electoral votes properly. So it's imperative that Congress do the fix that it needs, and the Supreme Court issue can be considered separately.